Just thank you and welcome to this panel on new approaches, theoretical and methodological, to diversity in international arbitration. Unfortunately, we've had some withdrawals, one at the last minute. So Monica Pruskaya and Henry Allen Blair are both dealing with family issues and unfortunately will not be able to join us. However, I am delighted to welcome Hosna Shekhatar and Mansour Vesali Mahmoud, who will be presenting their paper on critical theory approaches to diversity in international law. I'll let them introduce the paper itself, but first say a little bit about who I am and why I'm here and who they are. So my name is Joshua Carton. I'm a Canadian academic and arbitrator at Queen's University in Kingston, Ontario. I'm very proud to be one of the co-organizers of this conference, along with Giorgio Colombo, Shala Ali, and Philip Balcherzak. And I'm delighted to welcome our speakers today. Hosna Shekhatar is a Mayor's PhD fellow at the Institute for Private Law at Leiden University and has been a lecturer in the LLM and Advanced Studies in International Civil and Commercial Law. Her doctoral research focuses on the most just division of regulatory authority between legal orders in the life cycle of sanction-related arbitrations. And the working title of her PhD dissertation is When Economic Sanctions Meet International Commercial Arbitration, the Quest for Just Allocation of Regulatory Authority. She completed her LLM also at Leiden in 2017 and obtained a master's degree in international dispute settlement from the Graduate Institute in Geneva. Her main research interests are in international arbitration, private international law, intellectual property law, economic sanctions, transnational law, and normative interactions. Hosna's co-author is Mansour Vesali Mahmoud. Mansour completed his bachelor's, master's, and PhD, all in law, from Shahid Beheshti University in Tehran. He also holds an LLM in international dispute settlement from the Graduate Institute of Geneva. And he's taught arbitration, conflict of laws, and international commercial law as a guest lecturer in his native Iran. The main areas of his research and teaching are also international arbitration, commercial and investment, private international law, and public international law. So without any further delay, I'm going to welcome Hosna and Mansour to share their screen and to begin whenever you're ready.
Sure. Can you see my screen now?
I can, thank you.
Okay, perfect. Hello, everyone. Thank you very much, Josh and Giorgio, for organizing such a stimulating conference. It's a great honor and privilege to be part of this panel, and both Mansour and I are looking forward to your comments and feedback on our paper. So I have a few slides to share. I will start this presentation with a brief introduction, which provides some necessary background for the central idea of our paper. And Mansour will then take over to discuss the conceptual groundwork of the central idea of our paper, which is commercial arbitration through a narrative of hegemony. He will then specifically discuss the issue of commercial arbitration and claims to transnationality. I will then be back again, and I will discuss the theme of epistemic community in commercial arbitration through a narrative of hegemony, and then I will end this presentation with some concluding remarks, and hopefully we can have some fruitful discussions. Well, the long title of our paper is Dynamics of Transnationality and Epistemic Community in Commercial Arbitration, Rethinking Through a Narrative of Hegemony. Why we chose this topic? Well, basically, the reason we chose this topic was because despite increasingly diversified discourses in international arbitration, commercial arbitration remains a relatively under-theorized subject. And in particular, far too little attention has been paid to analyzing arbitration through a prism of post-colonial studies. And what do we mean by a post-colonial perspective? Well, a post-colonial perspective, there's no such a thing as a unified theory of post-colonialism, but a post-colonial perspective can be widely understood as a conceptual reorientation towards power and wealth disparities in the aftermath of the end of the formal colonial era. As such, it seeks to bring marginalized events and peoples back to the narrative and opens the door for taking broader power and structures into account. Against this background, our central research question is whether, and if so, to what extent the transnational authority of international commercial arbitration as a private method of resolution backed by the imperium of states is called into question under a post-colonial narrative of arbitration. More specifically, our paper seeks to revisit the transnational autonomy of international commercial arbitration by drawing on the concept of hegemony. And what do we mean by hegemony? Well, in post-colonial theory, the term hegemony is a colonial construct which refers to a predominant discourse that undermines the indigenous discourses that challenge it. More specifically, Western hegemony denotes a historical and cultural influence of colonialism, leading to the dispersal of Western customs throughout the world. One might question the relevance of such narrative for studying arbitration in its present modern shape. Well, it's true that post-colonial theory shows the impositions of colonial laws on the colonized regions in the past, but it's also concerned with how colonial laws continue to have contemporary relevance as an instrument of hegemony. In fact, post-colonialism in itself questions the end of colonialism. It recognizes the continued and troubling presence and influence of colonialism until today. So a post-colonial narrative of international commercial arbitration refers to the ongoing effects that colonial encounters, dispositions, and power have in shaping the familiar structure of arbitration in its present shape and form. We are of the opinion that these historical world power structures are relevant for some of the most pressing issues within the field of international commercial arbitration. Issues such as diversity as to the actors and cultures, legitimacy of lawmaking, and clashes between arbitration as a private justice and the regulatory space of states. The resulting uncertainties from these issues have the potential to undermine the international commercial arbitration's legitimacy and popularity as a system of international dispute resolution in an emerging global legal order. Based on these considerations, we have selected to study two themes, namely the claims on transnationality of international commercial arbitration and the concept of epistemic community within international commercial arbitration through a narrative of hegemony. This choice was made due to the potential relevance of these two subjects to the debate on how concepts and practices in international arbitration have been shaped under the hegemony and influence of Western legal traditions. Now, I'll hand over the screen to Mansour, who will discuss a narrative of hegemony in international commercial arbitration.
Thanks, Husna. Hello, everyone. I'm very happy to have this opportunity to present and discuss ideas on diversity in international arbitration. I should say big thanks to Josh, Giorgio, and other organizers of the conference. And I'm really honored and privileged to be in this panel moderated by Josh. So continuing our presentation, firstly, I'm going to give a brief overview of a narrative of hegemony international arbitration, which we have used as the ground for our analysis of the two selected issues in international commercial arbitration. And then secondly, I will address the first of the selected issues, and my co-author Hosna will go on with the second selected issue and the conclusion of our presentation. So without further ado, I'll get to the theoretical framework of our presentation. The narrative of hegemony in international commercial arbitration. There is a presumption in arbitration literature that arbitration is mostly about economic and commercial disputes. And I mean by arbitration, specifically the international commercial arbitration. And the presumption that arbitration provides for a purely legal forum to deal with such disputes. However, we believe that the starting point in a discussion of hegemony in international commercial arbitration is that commercial arbitration is highly political. Although there are mechanisms in international commercial arbitration to guarantee impartiality and independence of the arbitrators, international commercial arbitration is usually taking place in a political setting. In addition, we argue that arbitration, even in its most practical and technical aspects, could be political. Many examples could be brought up in which non-legal considerations in international arbitration have come into play to influence the proceedings and hearings. A very illustrative example is an ICC arbitration in which the parties had fixed Addis Ababa as the seat of arbitration. And at the same time, they had empowered the tribunal to choose another place as the physical seat to conduct arbitral proceedings. And then upon the request of the claimant, the tribunal decided to hold the hearings in Paris. The reasoning of the tribunal was not adequately substantiated. The argument was the significant travel time from Europe to Addis Ababa and the relative difficulty of coordinating travel arrangements for the non-Ethiopian party, counsel, the arbitrators, and the non-Ethiopian witnesses. This was apparently just for the sake of the convenience of the European party and the European individuals involved in the arbitration proceedings. The politicized environment of arbitration is a foundational myth of arbitration today. This is why the history of commercial arbitration is tightly related to the political developments such as decolonization and nationalizations. And more specifically, the well-known oil nationalization disputes mark the commencement of the blossoming of modern international commercial arbitration. These oil arbitrations may be described as the opposition of the North and South. International arbitration was used as a means to legalize a highly political conflict over nationalizations and also detach them from domestic laws and detach the cases arising from the nationalizations from domestic laws with the help of theories such as internationalization of state contracts. Can you move on to the next slide, please? We may see this background with the fact that gunboat diplomacy, that's to say, the use of military force and coercion, as well as capitulation treaties. And I mean treaties based on which a state agrees not to exercise jurisdiction over nationals of the other state party to the capitulation treaty. These instruments were used by Western powers to protect the economic interests of their nationals in other territories. After decolonization and other related political movements, this couldn't be the case anymore. I mean, the capitulation treaties and gunboat diplomacy. So international arbitration could be promoted as a justified alternative. because it was a legal institution with defined procedures. The important point here is that the pattern of economic relations between the North and South did not change in a meaningful way after the wave of decolonization and nationalizations. So the rise of arbitration should be seen in the very same context. Based on this very brief historical background, we believe that one way to theorize the interaction between the international commercial arbitration and the broader context of the economic and political relations is looking at it through the concept of hegemony. With reference to international law, for instance, Marty Koskeniemi, as a distinguished international law scholar, believes that international law appears through articulating the political references of the actors in international law by invoking legal rules and imposing their own interpretation of the rules. We argue that a similar process has taken place with respect to international commercial arbitration under the hegemony of Western powers. Under the Gramscian concept of hegemony, is achieved not only by the use of coercion, but also through submission to a domination by consent. A process of rationalization and justification facilitates and makes such consensual domination possible. Such rationalization and naturalization of international commercial arbitration has been in the form of transforming the larger context of the North-South conflict into a legal scene, or say a legal battle between the North and South. This has resulted in the legitimacy for arbitration. That's to say that greater political and economic questions were transposed into a purely legal field, which was promoted as a cross-border dispute settlement system based on the legal rules. As a final point in setting the theoretical framework of our presentation, I should say that under a hegemony narrative of international commercial arbitration, we cannot say that just because colonization is gone, then issues of power and politics is not legitimate to be raised in arbitration. Today, the hegemonic view of arbitration would raise more forcefully challenges to sustainable diversity in international commercial arbitration, which is the subject of this conference. And here I come to the first selected topic, which we have chosen to view through the framework I tried to briefly present here. And this is the claims to transnationality in international arbitration. So as I presented the framework for international arbitration, which is based on the concept of hegemony, I will get to the concept of transnationality. This topic addresses the claims of transnationality in commercial arbitration. There is a vast literature on transnational arbitral order and transnationality element in commercial arbitration. There has also been much attention to this transnational discourse in recent years in the broader context of global legal pluralism in legal theory discussions. Here, I'm not going deep into the concept of transnational legal order or arbitral legal order as a transnational system, but I should mention that the advocates of the transnational approach point to a strong perception among arbitrators that they do not exercise a judicial power or judicial role, which is in the benefit of they are not exercising a judicial mandate on behalf of any national legal system, but rather they perform a judicial mandate, which is in the benefit of the international community. And I will get back to this element of international community benefit in a bit. Many points might be raised from the standpoint we have tried to develop in our paper. Here I focus on 2 points. If we look at the transnational discourse in arbitration from the viewpoint of hegemony that focuses on the formation of the dominant view through the process of rationalization, we see that arbitration is promoted as an institution serving public purposes. Here, let's recall that advocates of transnational norms usually refer to the international community benefit. So it is manifested as a matter of public interest. Based on this public interest, many attempts have been made to detach international arbitration from the purview of domestic systems as much as possible. We borrow the second point from the legal realist approach. According to the legal realism, there is a constant tension between power and reason in every legal system. Viewing from this realist approach, the American and European legal cultures would be the main source of inspiration for the formation of transnational rules in international commercial arbitration. And this brings me to my final point here. Dynamics of transnational arbitration are mainly under the influence of Western legal systems. So the hegemony of Western legal cultures would be inevitable under this perspective. The comparative law method, which has been suggested as a technique to identify transnational rules, might be at the risk of creating such hegemony. Comparative law is not so much concerned with concrete solutions for real-life disputes, and rather it's a scientific endeavor with its own objectives and purposes. So we think that the use of arbitration to come up with concrete solutions to real cases should be made with this point in mind. And my co-author and I are looking forward to your comments and feedback, and I'll give the floor to my co-author, Hosna.
Thank you very much. So now I'll discuss our second select issue, which is the epistemic community in international commercial arbitration. Well, international arbitration scholarship makes increasing use of the expression epistemic community. The concept of epistemic community was first developed in the field of international relations, and it refers to a network of professionals with recognized expertise and competence in a particular domain and an authoritative claim to policy relevant knowledge within the domain or issue areas. The members of these epistemic communities typically have a reputation for impartial expertise. This concept can be employed to explain the control over and the circulation of information and knowledge within the field of international commercial arbitration. Today, we can think of a global community of arbitral practitioners and scholars with interest and expertise in legitimating arbitration. The members of this community has shaped their own community-specific norms, which guide the behavior of the members of the group in carrying out their tasks, and how this is done, and what are the attributes of this arbitral epistemic community. Well, in particular, regular interaction of the members of arbitral epistemic community, despite all of the differences in background that they have, lead to cross-fertilization and homogenization of their views on the issues relevant to the practice of arbitration. Further, members of the epistemic community of arbitration, after having confronted similar issues with regard to specific questions, they typically acquire a shared set of normative and principled beliefs, which provide them with some sort of internal criteria for validating knowledge within their field. In addition, many of these experts or practitioners employ scholarly work and publications as a channel of learning and communication. And this makes their role as the value providers of the social field of arbitration even more explicit and evident. It's noteworthy that these players have a clear collective interest in the protection of the industry of arbitration. This collective interest creates sufficient incentives for producing studies that protect the status quo or advocate the expansion of the field. In short, the participants of the epistemic community of arbitration have been able to influence policymaking in international commercial arbitration, both at national and international levels. And here we borrow the terminology from Katharina Pistor in her book, The Code of Capital, which we really recommend to everyone. We believe that these members of the community or these legal experts are in fact the masters of the code who actively fashion new law, and they are central to the coding of capital and distribution of wealth in society. These masters of the code, regardless of their ethnic background, are often trained at Western elite law schools and are later employed by top law firms in Europe or North America. Indeed, despite all of the attempts to address ethnic diversity of key players in international commercial arbitration, teaching and training in international arbitration law is predominantly shaped by a Western outlook. We argue that this phenomenon of epistemic community of arbitration is also closely linked to the transnational law discourse in arbitration, which we earlier discussed. And how these two issues are linked? Well, firstly, the development of transnational norms is mainly furthered and advocated by the recognized community of scholars and practitioners of arbitration, meaning that there is a causal relationship between the developments of principled beliefs within the community, and then these beliefs and shared normative frameworks are introduced in global harmonization efforts of, for instance, arbitral practice. Further, common interpretive policies have been developed within the community, and these policies influence the meaning and application of legal rules. For instance, according to Professor Gabriel Kaufman-Kohler, we can see a tendency towards transnationalization in the way that arbitrators color the applicable law when interpreting the contract. Meaning that when a specific national law is applicable to specific dispute, we often see that the tribunal applies the national law in question and supplements it with general principles of law deemed to be transnational. For instance, unidroit principle applicable national law in order to avoid the consequences which are deemed inadequate or unjust. And thereby they give a corrective function to the transnational norms, which can even sometimes override the application of national laws. Certainly not to be overlooked in this discussion is the importance of the label of law in this transnational law discourse. By granting the status of law to a subset of norms, we actually empower certain individuals and institutions who are acting as lawmakers, who are generating these norms as law. And in a way, we are redistributing political power. Simply put, characterization of a regime as law results in the normative superiority of that particular regime over all other social or moral norms which might exist. And this results, or this translates into real power for those who generate norms to be regarded as law. Therefore, we argue that theorizing about transnational law in arbitration can be used to advance the interests of the epistemic community in the protection of the industry of arbitration, which in turn is arguably tied to the interests of the global capital markets. And this brings me to our brief concluding remarks. Well, in our paper, we make no claim to present an alternative for the existing legal order of arbitration or substituting it with regional or local mechanisms that might exist. That's not our claim. Rather, we argue that any meaningful attempts in the direction of sustainable diversity in international arbitration should consider and acknowledge these historical world power structures that have influenced the transnational authority of arbitration as an institution which has been developed under the influence of Western legal traditions. We hope that revisiting these concepts through the narrative of hegemony can offer fresh insights for future reforms in introducing sustainable diversity in arbitration. And with this, I'd like to end this presentation.
Thank you very much, Hosna and Mansour. I see we have some members of the audience, and I want to give them a chance to ask questions and continue the discussion. But perhaps I'll take the chair's prerogative and start things off. I was taken especially with what you were saying at the very end there, because it's consistent with some of the more recent research that I've been working on together with the group on arbitration practices across Europe, and not mostly published yet. Unfortunately, we got delayed by the pandemic as so much other research did. But one of the things we found is that there isn't really a European arbitration community except at sort of the very highest level of the highest stakes cases and a relatively narrow elite set of practitioners. So one of the things, so I think that sort of empirical reality underlying your theoretical approach really is significant. What I wanted to ask is, given that you don't necessarily say that the current epistemic community needs to be overturned, one of the interesting developments of the last, let's say, decade in international arbitration has been, I'll put it bluntly, wealthy post-colonial states that have themselves asserted some control over the arbitration process and the arbitration community. And maybe the paradigm examples would be Singapore in Asia, in East Asia, the UAE, especially Dubai in the Middle East. So I'm curious whether you think groups like that, policy changes like the recent sort of expulsion of the LCIA from Dubai, do they represent an overturning of the post-colonial patterns, or do they simply represent former colonies, or not literally colonies in some cases, but states that were on the sharp end of hegemony, exploiting exactly the same tools that the former colonizers used against them?
Mansour, do you want to get started, or?
Go ahead.
Okay, so
Please.
yes, first of all, thank you very much for your very interesting question. And I think we should certainly give further thought to it when we are revising our paper. But I think these kind of initiatives and all of these changes, of course, they manifest some sort of change in the landscape, but I believe these are more in the direction of using the same tools that were used against colonized states at a certain point. So I do not necessarily think that local perspectives or new perspectives are introduced into the narrative. I think it's the same tools, the same means used by certain countries in the Middle East or in Asia, mainly by people who have been trained and educated in Western countries. And even if you look at the arbitration laws of these countries, they are mainly influenced by the mainstream transnational arbitration paradigm. So I am not sure if they undermine the hegemony of Western legal traditions, but it by no means means that they're not significant. But I'm not sure that the narrative is changing. But I don't know, Mansour, do you want to add something?
No, I agree. I completely agree with you, and I don't think that these movements are changing the paradigms, the main paradigms in international arbitration meaningfully and in a meaningful and effective way. As Hosna said, the individuals are mostly trained in Europe, and the fact is that there are many Western lawyers working in Middle East law firms, and so I don't think that this is changing completely the perspective for future contribution of other voices in international arbitration mainstream.
However, I think we do agree that competition in the market in general provides everybody with some benefits. So it's of course in itself valuable, but perhaps it's not a paradigm shift.
Right, thank you. It's very interesting. I see Giorgio has his virtual hand up, and I will turn the microphone over to you, Giorgio. But just first, I want to encourage any other members of the audience to do the same, to use that raise hand function, and I'll call on you afterward. Giorgio, please go ahead.
Thank you. Thank you very much for this very thought-provoking presentation. I really enjoyed that. As you know, and as was mentioning in the introduction to the general introduction to the conference, we have a popularity crisis of arbitration now, especially in the field of investment arbitration. Some people say arbitration is kind of rotten, is this tool of oppression, can't be saved. We need to move towards investment courts and these kind of things. And other people say, well, the tool in itself is neutral. Arbitration is a procedure. It can be weaponized, it can be used in exploitative terms, but the procedure itself, it's neutral. So the solution is not changing the system with the investment courts, but it's just like providing legal education and making sure that everybody plays by the same rules. And so my first question is, like, where do you stand on this debate? What's your opinion? And my second question, which I understand is a deep philosophical question, so don't bother answering if it leads you too far. I fully agree that the arbitration landscape has been shaped by the Western legal tradition, whatever that means. But is there any alternative to that? In the sense that I study occasionally traditional dispute resolution, and it's very fascinating from an anthropological perspective. But is there any alternative to the world of arbitration as we know it? So yeah, thank you very much. It was really a very fascinating presentation, and I agree with you and Tuck and Young. It's like decolonization is not a metaphor, and decolonization without a change in the economic structure is just window dressing to appease the former colonizers. But yes, I'm really curious about your opinion.
Many thanks. Mansour, do you want to start?
Go ahead.
Answering. I think you are more experienced with the investment arbitration discourse. So if you can start with the first part of the question, and then I'll take
yeah, okay. With respect to the first question, first of all, thank you, George, for your comments and questions. With respect to the first question, I also think that there is no alternative to arbitration in investment disputes, and we don't think that this has to be completely overturned and another dispute resolution method be added to the international investment dispute settlement system. And with respect to the second question, we think that the Western cultures are the main source of inspiration for the norms that are actually practiced in international arbitration, and we think that the alternative, we also think that there is no alternative to this, but we should engage more lawyers and more representations from developing countries and non-Western legal cultures to, for example, form soft law instruments in international arbitration, because we see that they are really significant in the practice of international arbitration. But the thing is that the soft law instruments that are mostly effective in the practice of international arbitration are mostly inspired by Western legal cultures, and we think that this might be fixed by more representation and engagement on the side of non-Western legal cultures. Go ahead, Hosna.
Yeah, I'd like to add a few points. I think we also believe that arbitration is not inherently biased. It's a tool and it can be used for different purposes. I think if you look at the historical developments, I think the academic discourse or the discourse within this epistemic community of arbitration maybe made it possible to be used in a biased way or in a way which is not adequate for representing all of the cultures and regions of the world. But we do not think that it's inherently biased as a legal institution. And this ties into the second question about the alternative. Since it's not inherently biased, I think we shouldn't necessarily think of an alternative for the system. Rather, as Mansour suggested, we maybe can widen the scope of participation of different actors in this social field, which seems now a bit closed, especially when we think of this transnationality. Those norms advocated as transnational, they can be, their transnationality can be questions. Of course, we are not suggesting that they should be substituted, for instance, by local Chinese norms or Islamic principles. That's not our suggestion. But affixing the label of law to certain norms which have roots in perhaps Western European legal traditions, that's a bit questionable, and that actually empowers certain powers. So I think you are right, you're absolutely right. We cannot overturn this system completely. It's all about widening the scope and informing this system from other discourses that exist and just making it more diverse, which again, I know it's easier said than done.
Thank you very much.
Thank you. Is there anyone else from the audience who would like to pose a question or a comment? Well, then perhaps I'll jump in the meantime. I've actually had two conversations with colleagues recently on topics that I think are very close to yours, and there might be some fruitful possibilities for collaboration. And one was, I was chatting a couple of weeks ago with a young French, well, originally Brazilian lawyer, Mickiewicz, who's trying to write a global history of arbitration. And one of the things that he's discovered is that a global history of arbitration effectively is a post-colonial history. And so my first question to you is, I'm curious whether you would agree and what difference that makes if you do agree. And then the second, one of my colleagues here at Queen's is working on a project entitled Traveling Judges, where they're looking at the judges of international commercial courts and other similar entities who are brought in from other countries. And I think that's very much in line with what you found, that overwhelmingly this phenomenon is a phenomenon of the former British Empire, and overwhelmingly the judges actually brought in are British barristers and retired judges. So that is not so much a question for you, but a suggestion that that what you're writing about, it's a transnational commercial dispute resolution phenomena more broadly than it is specifically an arbitration phenomenon.
Could you please repeat your first question,
So
Josh?
the first question was, is there a global history of arbitration other than a post-colonial history? And if not, then what difference does that make?
I think it also depends how we define arbitration, because in many arbitration textbooks, they start with all of these ancient practices of dispute resolution in Islamic tradition and in other parts of the world. But I think, as Jan Paulsen mentions in his book, The Idea of Arbitration, these are not arbitration in its modern sense. For instance, they keep referring to one Islamic construct for resolving dispute resolution, but that's more of mediation. It's not binding arbitration. So I think many of the arbitration scholars or practitioners try to sell this idea that this is a global phenomena rooted in ancient times. But I think it's true. Modern arbitration is actually a post-colonial construct, and it's difficult to see it as a global legal institution which has roots in ancient times. So I think I do agree with your colleague that, yeah, there's no history of arbitration in its modern sense, rather than what happened in the post-colonial era. Of course, the colonial era is also very relevant, like the mixed courts. I think they are some sort of the origins of ideas of dispute resolution, like arbitration. Yeah, but that's how I see the issue. I don't know if Mansour has any other ideas on the topic.
I think that yeah, I agree. I agree with that statement, but I can add that, for instance, in Africa, colonies couldn't buy into the traditional concepts and methods of dispute settlement in Africa, which were mostly customary means of dispute settlement, and then they went on to impose their idea of arbitration to resolve disputes between, for instance, traders, European traders, and the traders in colonized territories. Yeah, and I don't think that there is another history of arbitration rather than post-colonial history.
But being a post-colonial construct, again, it doesn't mean that it cannot be revisited, and we cannot think of rebalancing the power in this construct. So even if it was created basically with the hegemony of Western legal cultures in mind, we argue that this legal construct is capable of being de-hegemonized.
Thank you very much for that interesting answer. We have a little bit of time, so I'll give one more chance for members of the audience to ask a question. But I also think that that was a great note to end on. All right, seeing none, I'm going to thank very much our speakers, Hosna and Mansour, for their interesting paper and presentation today. Thanks also to the members of the audience, who I hope enjoyed the paper as much as I did. Thank you all.
Thanks, Josh. Thanks.
Thank you very much. It was really a great honor to be part of this panel.
Thanks, everyone. So for those of you who weren't here at the very beginning, unfortunately, we've lost both of our other speakers due to recent illness in one case. So we're going to have to leave things there. You're all welcome to join the other panel that is currently in progress. And I hope that we'll see you for the brief closing remarks. Thank you, everybody.
Thank you.